read to the learned court the paragraph you are talking of, a loose fire that is outside.
Sorry?
Read to the paragraph where you're...
Your Honor, that is my preliminary.
It is not there.
I need not to include all
I've only asked a simple thing.
I think
It is not there.
the defense counsel, I'm trying to explain to the Honorable Court
Yes.
the question.
Yes.
And I want to elaborate for you so that you can have facts which you do not have.
Yes.
Even if your clients will be giving you facts, you already have some facts from the investigating officer. There's a loose firearm. Those are the informations I need not to reveal them in court, neither in papers. So just take it aside, I explained it to you, Your Honor, for the consumption of your case.
Then that's all for cross-examination. I can do my submissions
Yes.
based on the
Thank you,
cross-examination.
Your Honor.
The officer can be discharged.
Yes. Inspector. Thank you, Your Honor. Yes.
Your Honor, before I respond to the affidavit and the sentiments of the learned State Council, I wish to make an oral application that the 4 respondents be entered into a reasonable cash bail or bond terms on the basis that the reasons provided by the state to keep the officers, the respondents, in custody does not disclose any compelling reasons as provided for by the Constitution of Kenya and the Criminal Procedure Code. Your Honor, the state starts by saying the offense was committed, the alleged offense was committed at 0100 hours. And the scene was reconstructed. No material has been presented before this court. As provided for by the authorities of Dwight Sagare, where Justice Corril.
The authority of?
Dwight Sagare.
How do you spell that?
DWRIGT. DWRIGT. Sagare is SAGARY. Where Justice Corril made it very clear that
Which Corril? Well done.
Justice, not your Justice, the lady Justice, Lady
Yes.
Corril put it that material evidence must be produced before the court to support an allegation of interference by the respondents. Secondly, the second issue why the state wants them detained is to allow the state to do ballistic analysis. You know, this is a scientific process. Conducted by experts from the DCI to the exclusion of the four. They are not required. And therefore, detaining them on that reason is not sufficient. Third reason, Your Honor, why the state wants to detain them is in paragraph 11, that there are ongoing investigations and they'll interfere with the witnesses. The same authority I've referred to, Justice Correa, said that it must be demonstrated one, that they have actually attempted to interfere. And interference with witnesses is a crime by itself. Where the police will record a complaint of interference and charge whoever is interfering with the administration of justice. That is not before you, Your Honor. Therefore, that is mere apprehension that they are likely to. And in the case of J. Alden, the authority, the court is aware about all those authorities, and the state is aware about those authorities. Mere apprehension by the prosecution is not sufficient reasons to curtail the liberty of an individual. You know, this has been dealt with in the case of Obado, the governor of Migori, the Michael Oyamo case that went to the Court of Appeal. The court upheld that if there is fear of interference, the trial court is clothed with the powers to impose conditions. The four respondents found themselves in Maimayu by virtue of them being police officers. It is work that took them there. The court, therefore, can order they be released on bail and keep away from Maimayu, either 100 kilometers away or 200 kilometers away. You know, also, in the celebrated case of Oscar Sudi Kipchumba, Professor Judge Ngugi, then sitting in Nakuru High Court, told the state that Kenyans pay taxes to fund the police to do their job. The police cannot cry that they fear 4 simple Kenyans being out. This is a country, we have a very strong police force. If any of those 4 interfere with the witnesses, you know, the court will cancel their bond terms. And they are all police officers. They know that they must respect the rule of law. Therefore, Your Honor, paragraph 11 of the interference is not a compelling reason. Your Honor, paragraph 12 has produced another reason the state wants you to use to detain them, that autopsy or postmortem has not been conducted. Your Honor, none of this is a trained pathologist. They are mere police constables. They will not even be required to identify the body because they are not family members. This is a scientific process done by medical staffs and police officers, plus the family. Therefore, that reason, postmortem can be done without them. You know, you have also been told about Section 14, the gravity of the offense. That if convicted or if they are charged, they are facing grave offenses of murder or robbery with violence. That was then, before 2010. After 2010, Kenyans enacted Article 49, 1H of the Constitution. And also enacted Article 150, Article 50 of the Constitution, that these are people presumed to be innocent. They have not been convicted of the alleged offense. And therefore, the gravity of the offense is not reason enough to detain these people. Your Honor, I urge the court to take judicial notice of the number of people who have been charged and have been acquitted. The reason why the judiciary was created is to see the evidence and convict if the evidence is sufficient. For now, the question before you, Your Honor, is whether there has been compelling reasons to deny these people their freedom. Your Honor, of the affidavit, it is my submission that the state has not produced any compelling reasons as to why they need 21 days in custody. These are all police officers. The deceased is a police officer. The notion that police officers cannot be released on bail by virtue of them being highly trained in the art of guns and investigation is condemning police officers and everybody in the disciplined force, that on the basis of their employment as police officers, they must be discriminated negatively. You know, before you are respondents, alluding that police officers are dangerous people. And in a week's time, 10,000 young youths are going to be employed into the police. It's telling Kenyans that it is a job not worth looking for. We have a duty to protect the image of the police and let them not be condemned because they are police officers. You know, you have been told there is a loose gun, a loose fire. All these officers were issued with.
There's no point of being repetitive. Can I take the directions?
Strangely, I am going on leave from Monday. Today is Friday. So you will have to bear with me. I will deliver this at 3 p.m. I have to deliver the ruling at 3 p.m. because I will be going on leave from Monday.
That's
so the other alternative is if I'll deliver by 3 p.m.
3 p.m. is okay. That's good.
Or 3 p.m.
Much better.
3 p.m. All right, now call our matters. Thank you. Cause the next matter?
Criminal case E1133 of 2025, Alice